Good day to you all. Welcome to the first lecture of Shipmaster Business and Law lecture series. Today we'll discuss about contracts. Let's begin. What is contract? A contract is a legally binding agreement between two or more parties that sets out their rights and obligation. Right? So that contract can be written, maybe verbal or implied by conduct. However, it has to be valid and enforceable. Right? So the accept the generational wealth like your house, land, right? Other contract don't need to be in the written. Actually you can have oral contract, right? And that written contract actually don't need to have on the stamp or anything, right? So here you see we have got a contract which is written on the tissue. This is the famous contract of football player Messi, right? So this contract was written one in the tissue in a cafe of Argentina, where the scout and Messi's father decided that Messi will go to Barcelona and play for Barcelona. So you see, it is a $1 billion contract, $1 million contract, but it is written only on tissue paper, right? So you don't need to make a contract in the stamp and all that all the time. But again, we do that for our own safety purpose. What is an agreement? An agreement is a mutual understanding or arrangement between two or more parties about their respective rights and responsibilities. Unlike a contract, an agreement does not necessarily have to be legally binding. So for agreement, actually we don't need to be legally binding, right? And suppose two port authority, they have agreed that they will share their best practices, right? So they have agreed on some arrangement, but so for that, if one of the port authority doesn't share their best practices, actually other port authority cannot sue them, right? So that is the example of agreement. Let us see what is the difference between contract and agreement. In agreement are promises between parties that are more informal, sometimes unwritten, and based on trust. These make them enforceable in court, so parties are not liable if they break the terms. Agreements do not include consideration, that means an exchange of payment, goods or service. Whereas in contract, these contracts are more formal, written pacts that are enforceable in court as long as they contain certain elements. Using specific terms, clauses, languages, contracts outline the obligation parties must fulfill in exchange of payment, goods or services. That is the consideration aspect of the promise, right? So from this slide we understand that the basic difference between contract and agreement, that in the agreement the parties doesn't include the consideration or doesn't pay each other, whereas in the contract most of the time you'll see that we have got some consideration, right? There is an aspect of payment. We'll see more in detail later on, don't worry. Let us see what is the element of a contract. So in the contract we have got the 7 element. Basically the first one is offer. What is offer? So suppose somebody is willing to sell his car, so here he is offering his to sell his car, so that is the offer. And the second one is acceptance. What is the acceptance? Acceptance is somebody is willing to sell his car, and you have decided that you are going to buy his car, so you have accepted his offer, so that is the acceptance. Then consideration. This is the most important part of contract, where actually uh, both the parties agreed on a price or on a value under which the contract will be done, right? So maybe the car will be sold in $5,000. So for in the acceptance you have accepted that okay, you will buy the car $5,000, or you may bargain, right? Maybe I'll not buy it on the $5,000, I'll buy it on $4,000, or you may input some clause as well, right? You can sell that okay, I'll give you $5,000 if you give me this, right? So this is this is the consideration. So you have to write down all this consideration in your contract. Then intention. So both the party has to have a proper intention to buy and sell the car, right? Capacity. What is the capacity? It is the uh, a mental awareness, right? Both the parties should have the mental awareness to be involved in the contract. So both the party has to be mentally aware, and there has to be adult, right? So most of the country, the capacity is 18 years old. So if you're less than 18 years old, then actually you will not be able to uh, be a part of the contract, right? Legality. So there is the legality is the part where actually a contract has to be for a lawful things, for legal things, right? So you cannot you cannot make a contract like to sell maybe unlawful things like heroin or other unlawful things, right? So there is the legality side of the contract. So in the contract we've got different contract terms. The term of the contracts are the specific provision, condition and obligation agreed upon by the parties involved, right? Let us see what are the contract terms we have in the contract. In the contract we can have express term, implied term, condition, warranty, innominate term, right? So let us see what are those, and we'll have a table describing all the terms as well. Don't worry. Let's see what is the express term. So in the express term, the terms which is clearly stated, right? So in the charter party contract, you have clearly stated that you have to come to the discharge port on 5th of July, right? So that is the express term. Implied term, not explicitly stated but assumed by the law, right? So in the charter party contract, you're hiring a ship for maybe 1 month to carry the cargo, and uh, obviously the ship owner has to give you a COD ship. It may not be expressed in the contract, but the CODness is the implied, right? So if it is not COD ship, how can you can carry the cargo? So there's the implied term. Condition, a major term, right? So major term is in the charter party contract it is written that you have to come to the berth on maybe by 2 o'clock or 5th of July. If you don't come, the contract will be breached, right? So that is the major term. Warranty, some is small minor term, right? So maybe which will be expressed in the warranty, right? Innominate term. So these innominate terms, depending on the condition, it can be either major term or minor term, right? So we'll see those in the next slide. Don't worry. So here actually we have got a table. So here you see the express term clearly stated in writing or verbally by the parties, right? So in the maritime context, delivery date in charter party is 15 June 2025, right? So there is the express term. Implied term, not explicitly stated but assumed by the law. So seaworthiness of the vessel and the maritime law, right? So as you are taking a ship for charter, so the ship owner has to give you a seaworthy ship, right? Condition, a major term that goes to the root of the contract. Breach of condition can bring to the contract to an end, right? Vessel must arrive to a loading port on or before 1st of June, right? So if you don't arrive before 1st of June, actually your contract will be cancelled, so breached, and so that's called that's why it is the major term. Warranty, a minor term, right? The breach allows claim for damages but not termination, right? Ship crew must have valid medical certificate, right? So all the ship crew must have the valid. If the peace inspector found that the ship crew doesn't have the valid medical certificate, maybe the peace inspector may fine you or may detain you. For in that case, the cost of that detention will be carried by the by the ship owner itself, right? Because it was his duty to see the ship crew has got the valid medical certificate or not, right? Innominate terms that can be either condition or warranties, right? The terms which can be either major term or minor term depending on the breach of the impact, right? Like ETA clause, right? So depending on the severity of the delay, right? So it can be either major term or minor term, right? So suppose you have given a clause that okay, you have to reach on before 1st of June 2026, right? So that is the major term we have given, right? But the vessel has reached maybe 2nd of June, maybe at the morning 2 o'clock, right? So he has done only 2 hours late, right? So in that case, that term can be nominate time, right? So again, if he delays for like maybe so it can be we can call it warranty. Again, we can, if it delays maybe for 5 days, then it can be condition as well, right? So that is the innominate term. Performance and breach of contract, right? So what does it means? The performance means the fulfilling the obligation stipulated in the contract, right? So suppose you have you are in a contract to a vessel, right, from A to B. So once you have towed the vessel from A to B, so your contract is performed, right? Breach of contract. So this breach of contract occurs when party fails to perform any term of the contract, expressed or implied, without a legitimate legal cause, right? So you are a tag. You are under a contract to the vessel from A to B, but you couldn't finish the contract. In that case, the contract is breached, right? Anticipatory breach, right? So this anticipatory breach occurs when only one party indicates in advance that they will not fulfill their contractual obligation. So I take the same example. So you are a tag, and you are in a contract to carry the vessel from A to B, but due to some reason you have given a notice that he will not be able to finish the contract, right? So in that case, you have breached the contract, but you have given a notice. So that is that type of contract breach we call the anticipatory breach, right? So the remedies of the breach of contract. So these what are the remedy if you breach the contract? The first thing is the damage, right? So what is the damage? The monetary compensation to put their injured party in the position they would have been if the contract had been performed, right? So so this is the monetary compensation for breach of the contract. So you have decided that you'll breach the contract. In that case, you give some money yeah, I couldn't finish the contract, so that is the damage, right? The monetary compensation I'm giving you. Then specific performance, maybe a court order which will tell you that the breaching party to fulfill their obligation as per the contract, right? So suppose you have taken a contract to discharge cargo in certain port, right? And at some point you are not, as a ship owner, or as a ship owner, you're not willing to discharge the cargo anymore, right? You have in the middle of the cargo operation, you decide that I'll not discharge anymore, right? So in that case, the cargo owner went to court, and he brought a court order, so that the court order says that okay, you have to discharge full cargo in this port, right? So that is the specific performance. Injunction, an order preventing a party from doing something, right? So in that case, we take another example. So suppose you are in a port, and you have got some cargo, and you are ready to discharge those cargo to the cargo receiver, right? Now in that same port, you have got another party who wish to buy that cargo, and they want to give more money, right? In that case, you thought that okay, let's breach the previous contract, and I'll give the compensation, but I'll sell the cargo in a higher rate to the other party. In that case, the first party went to the court, and they can bring the injunction order. They can the injunction order saying that you cannot sell the cargo to the second party, right? So in that case, there is the injunction order, right? Restitution, restoring the injured party to the position they are in before the contract, right? So let's take an example, another example. So you are approaching to a port, and once you're approaching, you hit the jetty of the port. So what will happen? The jetty has broken. So now the port authority has arrested you, and they ask you the restitution money, right? So that means you have to agree that you will restore the jetty as previous condition. So then actually the port authority will let you go, right? So that is the restitution. Beside that, the discharge of contract, we can have the discharge of contract. This discharge of contract means the contract come to an end and the parties are freed from their obligation under it, right? So this discharge of contract can be done in these 4 ways. One can be performance, another can be agreement, another can be frustration, another can be breach, right? So let us see what is performance. So in the performance, we have both the party, they have fulfilled their contractual obligation, and we said that the contract is performed. Then you have got the agreement. Here both the party mutually agreed that they will end the contract, right? So you are a tug vessel and you are under contract to a ship from A to B, but in the middle of the passage, you both agree that you will not go to A to B and you will finish your contract at in the middle of the point, right, in C. So in that case, you finish the contract, right? Frustration, that is the very common in especially tow agent salvage. One will be discussing that one. We'll discuss that one. So this frustration is due to some unavoidable circumstances, it is impossible to perform, right? So suppose you are in a towage contract to carry to tow a ship from A to B, but due to some bad weather, the tow line has parted, right? And that's why you couldn't finish the contract, right? So this type of situation, we call it this type of breach of contract, we call it as discharge of contract, we call it frustration, right? So frustration is a situation where actually you are unable to finish the contract due to some unforeseeable or unforeseeable situation, right? Breach, right? And again, you can discharge the contract by breaching the contract, right? You are contracted to tow a ship from A to B, but at the middle of the path you said that okay, I'll breach the contract, right? I'll not go up to B. I'll finish the contract at point C. So you have breached the contract. So in that way, actually, you can discharge the contract. So as we have seen that there are different ways of discharging contract. So due to contract, we have got different procedure for resolving those dispute, right? So what are the procedure to resolve the dispute in the contract? The first way of resolving dispute is negotiation, right? What is negotiation? Negotiation is where you both the party you negotiate and you resolve the dispute between you two, right? Then the mediation. The mediation here actually a third party comes who actually work as a mediator and who will try to negotiate between these two party, and he will act like a bridge between these two party. Arbitration, it is very common in the maritime industry where actually a arbitrator decide who is going to pay what, right? Litigation, that is also very common. So normally we get this litigation where the contract is there is a huge dispute and both the party want to go to the court, and in the court by litigation they get the result, right? And then we have got the expert determination where actually we both the party go to an expert like a cargo surveyor to get the decision about the dispute, right? So we have got a table for this procedure for resolving contract. So like negotiation, right? So here actually for minor dispute, actually we have got the negotiation, and we normally finish the resolve the dispute between the contractual parties, right? Mediation, here sometimes we do it, and it is a semi-formal way of resolving dispute where actually a third party come and they act as a bridge between the contractual party, right? The arbitration, it is very formal, and which is very common. So a lot of the freight demurrage dispute and charter price dispute are done by the arbitration, and here the arbitrator come and they do they give the verdict, and they resolve the conflict, right, or they resolve the dispute. Litigation, which is very formal, actually it is very common in for large dispute, and here actually for complex legal issues we use the litigation. Expert determination, that is also very common, like it is very you'll see that will for cargo dispute we maybe we sometimes we call PNA surveyor, or maybe for some technical issue we call the hull and machinery surveyor to see what is the how much extent, how much how much the damage is, right, what is the extent of the damages, right. So for that we get we agree on the expert determination, right. So in that way we can resolve the contractual dispute. So that's all about contract. If you want to know more, let me know, and if you've got any query also, let me know, we can discuss in detail. Thank you very much. See you in the next lecture.